So now we have a point in which we are ready to look at a case to try to help understand what's being done in this case. And we've got a very interesting one. I like to think of this as the modern Chaplinsky case. When I am thinking of what are the handful of cases that I would use to talk to a general audience about how to understand Supreme Court analysis in the First Amendment, I think of Chaplinsky. I think of the West Virginia versus Barnett case. And the third one I think of is Alvarez versus the United States, because the question is so understandable. It's so basic. It's so apparently simple, but it's not simple, that everybody can really relate to the question. The question is going to be, does the First Amendment protect lying? Now, what do we mean by lying? There are lots of meanings attached to that word. I'm going to make it broader. Does the First Amendment protect misinformation, false information, actual lies, white lies, misunderstood information, all of those differences? When we look at the nature of misinformation or lying through the lens of Chaplinsky, we ask, is this information that has no social worth to the free marketplace of ideas? Is this information that could be harmful to the free marketplace of ideas? And if it is information that has no social worth or is harmful to the free marketplace of ideas, do we call it conduct? Do we say that the state can regulate it? Do we have such hostility toward it that we carve it out of the First Amendment, that it has no protection? Or are we saying that sometimes misinformation, lying, false information, sometimes that information can be put into the free marketplace of ideas, and the best combat for that, the best competition for it, would be truthful information, more exposure to that misinformation. Maybe there is a social value to misinformation. So it's not quite so clear, using Chaplinsky, how to determine whether this is regulatable conduct carved out of the First Amendment, or whether this is somewhat useful, if not maybe valuable, information and expression that should be protected in the free marketplace of ideas. The Alvarez case comes to us in 2012 from an individual who was on a water commission in California and who was heard to express many times that he had served in the military, that he had served in the Marines, that he had been shot at and that he had been injured during this service, and that he had won the Medal of Honor. When this person said that he had won the Medal of Honor, it then became a controversy under federal law, because the Congress had passed something called the Stolen Valor Act of 2005. And it was designed to protect against individuals falsely claiming that they had won military honors, and thus diminishing, in the view of Congress, the value of that medal and the value of service in the military, and thus harming the nation. You could lie all you wanted, but you couldn't lie about getting certain military honors. And the highest of those honors, of the 12 or so medals that were protected, was the Medal of Honor. What's not popularly understood is it also protected against lying about the Distinguished Service Cross, the Navy Cross, the Air Force Cross, the Silver and Bronze Stars, the Purple Heart, and a variety of additional combat ribbons and awards. The case involved a man named Xavier Alvarez. And the case came to the court when he introduced himself as, I'm a retired Marine of 25 years. I retired in the year 2001. Back in 1987, I was awarded the Congressional Medal of Honor. I got wounded many times by the same guy. That's from the lower federal court opinion transcript. None of it was true. He was indicted under the Stolen Valor Act. And here's what we want to do. We want to follow the technique that I just outlined about looking at the balance of the court. So what was the court in 2012? It was not the court that we see now. We're going back into the balanced era of the Supreme Court, and we're going back into the balanced era with the third of the three tipping point justices, Anthony Kennedy, in control of the court. And that makes a big difference because when we look at the court, 4-1-4, Kennedy in the middle, your immediate instinct would be, well, Alvarez is going to win because Kennedy's view of free speech is incredibly high. Kennedy believes that free speech should be protected using our levels of scrutiny analysis at the absolute highest level, strict scrutiny. Kennedy believes that the state or the Congress should have a compelling state interest. It should be the only possible way for the state to achieve their goal in order to regulate this speech. He believes that anybody has the right to say anything they want because it would be put into the free marketplace of ideas and other people would combat that view. And in fact, that was happening in this case. There were other people who had heard either reports of what Alvarez was saying or had heard what he was saying directly, and they had done some research, or they were in the military and they knew what he was saying was not true. So the process was working its way out in the free marketplace of ideas, and truth was combating this fictitious account of one's background. But once Alvarez was arrested, then we needed to know what the balance of power would be on the court among the 9 justices, who would control that majority opinion. Now, because John Roberts was in the majority, he had the power as the Chief Justice to pick the author of the opinion. Many times he picks, like other Chief Justices, picks himself to write these opinions, but he knew it was Anthony Kennedy's views on the protection of free speech that would unite the 6 members of the majority. He also knew that maybe the shakiest vote in that 6-person majority, the one that could maybe break up his majority, was Kennedy. So why not assign the opinion to Justice Kennedy and let him work this out? What I find fascinating about this case for my students to start this journey of looking at the balance of court and looking at the levels of scrutiny is that there are 3 opinions in this case, similar to what we saw in the Brown versus Entertainment Merchants Association case. You're going to see 2 justices, Anthony Kennedy and Stephen Breyer, both of whom are very close on the protection of free speech. Stephen Breyer also usually has a strict scrutiny level, high level of protection of free speech. Stephen Breyer usually is the person to say, we need to make sure that the free marketplace of ideas will operate, and I'm going to give maximum protection to the speaker for that purpose. But here, they're going to disagree. And they're going to disagree because each of them is going to use a different level of scrutiny to get to the same place. And then there are the 3 dissenters. And just like you would see when you look at this chart of where the court was in 2011, 2012, you will see that there are 3 hardline conservatives. And the 3 hardline conservatives are Samuel Alito, Antonin Scalia, and Clarence Thomas. And those 3 men are going to use an entirely different level of scrutiny from Kennedy in the majority and Breyer in the concurring opinion. And there's a question that I've not been able to resolve, and it's one of the things that we discuss in class. When I look at those three in dissent, they're not the same. Remember, it was Antonin Scalia who was so protective in the Brown versus EMA case of the right of free speech. It is Antonin Scalia in the hate speech area, the RAV case coming from Minnesota, who's very protective of freedom of speech. It made me wonder why Antonin Scalia is in dissent with Alito and Thomas, who are not so protective of speech, who have a view of carving out certain categories of expression and saying that they are not protected. Why is Antonin Scalia with them? Why is he not with either Anthony Kennedy in the majority or Stephen Breyer in the concurring opinion? I have a guess, and the guess is I would use my biographical skills. I would want to know something more about how Scalia saw this military award, how it might be affected by the knowledge that his son was serving in Afghanistan later on, and he was in the military, and maybe that's the framework that Scalia used, which led him, in this case, to be with the government regulating to protect the military honor and not voting as he did in Texas versus Johnson to protect the protester who was burning the American flag. It's one of those things that keeps law professors up at night trying to figure out why our justices is where they are. Anyway, back to our main story. Our main story is how do we use the levels of scrutiny to understand the results in this case? And it's pretty straightforward. Justice Kennedy looks at this prosecution and he says, what you have here is a prosecution against everybody who lies about military honor. You have content discrimination. A type of speech is banned by the government. Now, you might also add that you have viewpoint discrimination because Alvarez is saying that what I did in my fictitious service in the Marines in wartime was beneficial to the country, and should be honored. Kennedy believes that if you have this kind of content-based restriction on speech, that he should use the highest level of scrutiny, compelling state interest. The government should be required to prove this is the only possible way to achieve your goal. Now, he uses the phrase most exacting scrutiny. He goes back to the Caroline Products footnote phrase, but it actually is strict scrutiny. And he says the law fails that test. Because what he's doing is he's looking at the category of speech that he is talking about. He calls it falsity. Doesn't call it lying. He calls it falsity. And he says that in his opinion, falsity is not unprotected by the First Amendment. It's not conduct under the Chaplinsky rule. In his words, falsity alone may not suffice to bring the speech outside of the First Amendment. Since the Stolen Valor Act targets falsity, the Stolen Valor Act needs to be overturned. He also explains that the government had made no effort to explain why countermanding speech, why opposing speech to this falsity would not be the best way of achieving the goal of protecting the medal. Is there a possibility for the government to release information that would make it very clear that this fellow had not won the Medal of Honor? And in fact, it's a couple of clicks on Google to find out all of the living members of the Medal of Honor. And you see that that name is not on the list. And that's what some people did. So as far as Kennedy is concerned, there is no way that the government could could prosecute and successfully convict somebody like Alvarez, claiming that they had won the Medal of Honor for service in the military, because he was prepared to say the government didn't have compelling state interest, that people like Alvarez deserve strict scrutiny protection, and that it was possible that anything they said that was false, that was misinformation, that was lying, would in fact be protected, unless the government could show that the interest that they were trying to promote in protecting the medals was in fact compelling. When I read Stephen Breyer's concurring opinion, agreed to by Ruth Bader Ginsburg, I notice that he seems to be agreeing with a lot of what Kennedy is saying. He seems to be writing as though I too believe that regulating falsity, especially regulating falsity in this situation, should require strict scrutiny. I too believe that there should be a compelling state interest. Why are you protecting this medal? He seems to be saying that what he would use could have been strict scrutiny. But then he takes a very interesting turn. He does exactly what he did in the Brown versus Entertainment Merchants Association case, the violent video games case. He says, what the government is saying is that there is a harm that comes to the medal itself, to the military, and to all military persons who have won the medal. There's a harm that comes to them from somebody like Alvarez claiming that they won this award. And he seems to be saying, I would accept that justification as being compelling, but before I accept it, you have to prove what that harm is. And so he says, in the end, I'm going to use an intermediate balancing test. I'm going to look at the interests of Alvarez in making these statements, and I'm going to look at the interests of the government in regulating against these statements. And I'm going to require that the government give me sufficient proof to show that there is harm coming from what Alvarez is doing. I like this opinion a lot because it allows me to show the students, look what they've done. They've got an important governmental objective. Breyer seems to be agreeing with that, but they have not proven that taking this prosecution to court has met their important governmental objective. So he's actually showing us, I am in the intermediate level, but I'm very high in that zone of intermediate level. Think of me as being a lot like Kennedy, but I'm a little skeptical. The show me state from Missouri, show me the harm. If you can't show me the harm, I'm not going to allow you to prosecute because I can't see the benefit of your law. So you've got 6 justices who are basically in agreement that a lot of misinformation, certain types of lying may be perfectly protected. This case, I think, will become very important in cases dealing with social media apps and cases dealing with the internet. And I think you're going to see the analysis in these 2 opinions as being very helpful to the court in trying to explain what they will protect and what they will not protect on the internet and on social media. But be alert to whether they are using Kennedy's almost totally protective strict scrutiny level, or whether they are instead using Breyer's, let's use intermediate scrutiny, let's balance out the interests, and let's force the government to show the specific harm that is coming from what is on that social media or internet site. Now, the Alito opinion, Samuel Alito writing for Antonin Scalia and Clarence Thomas, is much more straightforward. They are simply deferring to Congress. They are saying that the military believes that it is so important that you not lie about the medals that you have won, that it can cost people their positions in the military. It can stain their legacy. Military individuals take this very, very seriously. And so they are assuming that if the government and the military say that false statements about metals inflict real harm, that in fact, there will be real harm from false statements about metals. They are telling us that for them, stolen valor is the same as a fighting word. For them, stolen valor is the same as obscenity or as libel or as slander. It is in Chaplinsky's rules of the two levels of interest. It is conduct. It is to be regulated. And we must protect the metals themselves. This is what Alito is saying. This total deference is saying that any rational person, any reasonable person would agree with the military that this one type of lying is so bad, is so harmful, has such dire consequences that it must be carved out of the First Amendment and it must be eliminated. When he writes like this, take a look back at his opinion in Snyder versus Phelps. Take a look back when he talks about the family of the military veteran who was killed in the war and they were trying to attend their son's funeral, knowing that the Westboro Baptists were 1,000 feet away with their signs castigating the military and the government, castigating the war making of the United States government. And it harmed them personally in their time of unimaginable grief. And for Alito, he was saying, this is not speech. This is conduct. This is a tort. This inflicts injury. And so I am going to use an intentional infliction of emotional distress, IIED. And I am going to carve that out of the First Amendment, and that protest by the Westboro Baptists is not protected for me. That's analogous to what Alito is doing here. This is intentional infliction of damage to the military metal, to the military, to the government, and I'm going to carve it out of the First Amendment. So your levels of scrutiny, 3 levels of scrutiny, 3 different opinions, 3 different levels of testing. It gives us a real sense of what the modern court has done with the levels of scrutiny and helps us not only to analyze how to approach these cases ourselves, but to better understand how wings of the court in the present day line up on these issues.